can a council tell me to go away until the bailiff comes knocking and basically refuse to help me? Now, the reason lots of people ask this is because lots of councils appear to be doing this at the moment, but I'm going to try and explain why that's unlawful and actually what you can do about it if that's what the council tells you, because not only should the council help you much sooner, you can potentially get compensation if that's what a council's told you to do, and that results in injustice. So in order to answer this question, I'm going to need to build it up from a number of little definitions of parts of housing law and kind of try and knit them all together. So I'm going to start with the definition of homelessness itself. Homelessness is very broad, as I've kind of said in other videos, but essentially if you have accommodation but it is unreasonable to continue to occupy, you are already legally homeless, and that might be because you can't afford the property or because you're at risk of abuse there. But it would also include potentially when a Section 21 notice is expired, as we'll see shortly. So that's the first thing you need to understand. The second thing to understand is that you are threatened with homelessness, which is a technical term, if it is likely you're going to become homeless within the next 56 days. And again, that's something that will kick in various different situations. All of this is covered in the Homelessness Code of Guidance, which I highly recommend you download. It's free PDF. It's basically the rules that councils have to follow. And although it's called guidance, it's basically telling councils how to interpret the law. So if the council doesn't follow something in this and you come to some sort of harm, you would probably be in the ballpark of compensation straight away. So as I say, it's well worth kind of having a flick through. What we're talking about today is all in chapter 6. That's the second thing, threatened with homelessness. The third thing that's probably worth saying at this point is if you make a homeless application, and what that basically means is if you approach any department of a housing authority, you ask them for help with housing and you give them reason to believe either that you're already homeless or that you're threatened with homelessness, you've immediately triggered a homeless application. Now, councils again are really terrible at actually picking up on this. They'll often gatekeep people and tell people to come back a few weeks later. But ultimately, if you ask a council for help and give them reason to believe that you might be homeless or threatened with homelessness, you've made a homeless application whether they like it or not. And actually, as soon as the council has reason to believe that you might be homeless, might be eligible and might be in priority need, they should immediately secure that accommodation is available, which is a fancy way of saying providing you with interim accommodation. So that's the third or fourth thing, can't remember, fourth thing. It's probably also worth talking about the prevention and the relief duty. So once you've made a homeless application, and notice that you can make a homeless application if you're threatened with homelessness as well as actually being homeless. So if you are threatened with homelessness, you've asked the council for help, you've given them reason to believe that you might be threatened with homelessness, they have to start some inquiries, and what they'll essentially want to do is work out if they are satisfied that you are in fact eligible for assistance, which is basically like having recourse to public funds, and that you are in fact threatened with homelessness. And that might involve a phone call to the landlord or something and find out if the landlord's actually serious about evicting you or if they just kind of served it to scare you and kind of make you pay or something, or whatever. The prevention duty then kicks in, and the prevention duty essentially entails that the council carry out a fairly in-depth assessment about every single household member's needs, why you've become homeless, what sort of accommodation you need, that sort of thing, and also come up with a plan with you called a personalised housing plan in terms of what they're going to do and what you need to do in order to prevent yourself from becoming homeless. So as I say, it's called prevention duty. Equally, if you make a homeless application and you're already homeless, so the council carry out some inquiries, they're satisfied that you are eligible and you are already legally homeless, then the relief duty kicks in immediately. And again, same sort of thing as a prevention duty. They've got to carry out an in-depth assessment of you and your household members' needs, why you became homeless, what type of accommodation you need, and again they should basically collaborate with you to form a personalised housing plan, which in both cases, both the relief duty and the prevention duty, needs to be reviewed regularly throughout that period of time. So you hear stories about how housing officers never actually contacting anyone. That's basically unlawful just on that basis alone, because they need to know what's happening, how things are developing, whether you have been able to find any accommodation, in order to work out how to keep that plan up to date. So with those in mind, as I say, it's quite a lot to take in, but there's some real key concepts there, so I'm hoping this is all helpful. So with that in mind, I'm going to try and go through essentially the sequence of events that happen between being served with a valid notice to quit and having the bailiff come knocking on your door and telling you to leave immediately. So there's a number of stages that happen in between. The Section 21 is called a notice to quit, which essentially is giving you notice that you need to leave, but that doesn't mean to say you need to leave on the date that that notice expires. Now, for the purpose of this exercise, let's assume that the notice to quit is actually valid, because lots of landlords don't actually know how to do it properly, but let's assume that this particular landlord does. So they've served a valid Section 21 notice. And just to make it easy, let's assume that you're automatically in priority needs. So let's say, for example, you're a parent with a dependent child or something. So essentially, there's 4 different stages between giving a Section 21 notice and the bailiff literally forcing you out, with all your belongings or whatever. So the Section 21 served, that has to be for at least 2 calendar months. And if you think about it, and this is important, a calendar month is going to be something like 30 or 31 days, depending which month it is. I guess February's 28 or whatever. But what that means is you're going to have at least, mathematically speaking, 59 days. At the very least, you're probably going to have 60, 61 or 62 days between getting that valid section 21 and actually that notice expiring. And that's significant because if you remember, you're threatened with homelessness if it is likely you'll become homeless within the next 56 days. So those first 3 or 4 or 5 days, you can't make a homeless application yet. You can contact the council. It's sensible at this point to contact the counsellor that covers your ward, just to kind of explain to them, ask them for help or whatever. But you can't technically make a homeless application yet because you're not likely to be homeless within 56 days. But once you get within 56 days of that notice expiring, then you can make a homeless application. Now, I've done a video recently about how you should do that. Don't ring up the council, don't walk in there in person, you do it all by email because it's a legal process. It's important that you cover a lot of different bases all at once. So check out that video if that's going to be interesting to you. So you make a homeless application, 56 days, the notice expires. At that point, the council have to accept the application and they need to make some inquiries, and they should very quickly work out that in fact, yes, you are threatened with homelessness and yes, you are eligible, so the prevention duty kicks in. And as I say, they carry out an assessment, they do a personalised housing plan and so on. But let's say nothing comes of that. Let's say they're unsuccessful, you're unsuccessful in actually doing anything. And so the notice to quit expires. Now this is what I'd call the first stage. So the notice to quit expires. The landlord then needs to apply to the courts for a possession order. So that can take several weeks depending on how efficient they are. Could take a bit longer, I guess. And in that period, the courts will send you a form to fill in if you're going to put in a defence. But let's assume there is no defence. Let's assume that it's it's a valid notice. You've got no exceptional circumstances. There's no kind of funny business going on with the landlord. So you've then got this period between landlord applying to get a possession order and actually getting a possession order. We'll call that stage 2. And then you've got from the point that the landlord gets the possession order, so the landlord then needs to apply for a bailiff's warrant, which again can take, several weeks depending on how efficient everything is. And so that's the third stage. And then the fourth stage is essentially the time between the judge granting that order and essentially the bailiff will have to come round to your home, serve it in person, and on that letter it will basically give you a few days, a week or something before you actually physically have to leave that property. So you've got 4 stages that can last 6 months quite easily in the real world. But actually what we're talking about here is we're trying to get you something sorted out right early on in this process. So as I say, you can make a homeless application in stage 1 as soon as you're within 56 days of that notice to quit expiring. And then this is where it gets interesting because in theory most people should be accepted as homeless when that notice to quit expires, so whatever date that would be. And the Code of Guidance, the chapter 6 of the Code of Guidance, has about 10 different paragraphs that cover this kind of issue, and it really starts by saying that councils can't have a blanket policy that says when they shall or shan't accept that someone is homeless during this period, because remember, transferring from being threatened with homelessness to actually being homeless, first of all, results in the prevention duty turning into the relief duty in effect, but crucially it could also be where you are then owed that interim accommodation duty under section 108 if, for example, you've got kids and it's very obvious you're in priority needs. This is where things start to matter. So if we start just looking at the Code of Guidance, so 6.33 essentially says that local authorities can't have blanket policies. It then suggests 6 different factors that the council should be looking at to work out at what point they need to accept that the person is actually homeless. And those 6 factors are the wishes of the tenant, and that might seem a weird one to say, but essentially in some situations a tenant might prefer to actually stay put, because let's say for example the tenant has lined up another property a couple of months down the line or something, and rather than move into temporary accommodation when the notice to quit expires, they would rather stay put, potentially even incur court costs potentially, but that means that they don't have to move the house twice and kind of solve some other issues. And so the tenant might actually want to stay put, but equally the tenant might want to get out of there as soon as possible so they don't risk coming under those court costs. So again, that's one of the factors the council need to look at. The second one is the position of the landlord, because again, some landlords serve section 21 notices with no real kind of wish to actually evict people. They might do it to scare them, to kind of pay up rent or whatever, or kind of pay off arrears or whatever it might be. But sometimes landlords aren't serious, things might change, they might change their mind about selling the property or whatever it would be. So the council needs to check that out. The third one would be the financial implications for both the tenant and the landlord should it go to court, because as soon as it's going to court, it's costing someone money. And actually landlords have successfully challenged councils and got compensation when the council has advised that tenant to stay put when there was no actual basis to do that. So that's the third one. The fourth one is the burden on the courts. So essentially councils should not be throwing cases unnecessarily to go through the courts when there's actually no real need to. The fifth one is that councils have to consider their relationship with the private rented sector. It's no good pissing every private landlord off, because all that happens is the private landlords won't work with them anymore, and they tell all their landlord friends not to work with the council either, and now the council hasn't got landlords to actually work with in terms of discharging other duties, so they're much worse off. So that's all pretty standard stuff, but the sixth one throws in some ambiguity, because it says that councils can also consider the financial implications on the council itself. And what happens in this situation is you've got 6 different factors you've got to look at. Housing officers just happen to zone into that last one, and they'll basically say, oh, we're really strapped for cash at the moment, we've got no choice. And they'll even sometimes go as far as saying that their policy is to tell people to wait until the bailiffs come knocking, which is definitely unlawful, as we'll find out shortly. So that's the kind of preamble the Code of Guidance goes into. But then it starts getting interesting, because it starts giving much more definitive guidance on what council should do at what point. And the first point, if we go back to our stages, is the end of that first stage, the expiry of that Section 21 notice. And the Code of Guidance says, if the notice to quit is valid, and if the attempts to kind of negotiate with the landlord have failed, and there is no defence if the case goes to court, then it is unlikely to be reasonable to continue to occupy that accommodation. Now, if you just remember that beginning bit I started off with, you are legally homeless if it is unreasonable to continue to occupy accommodation. So what should happen in the majority of cases at this point is the prevention duty should morph into the relief duty, and interim accommodation should be provided if the person might be homeless, might be eligible, might be in priority need. So that's our kind of first landmark. The second landmark is the end of that second stage, which is when the judge grants a possession order. And the Code of Guidance says that it is highly unlikely for it to be reasonable to continue to occupy the accommodation after that possession order has been granted. Again, I'm not even sure what situations might be exempt from that, but the vast majority of cases should therefore be that the council should accept you as homeless at that point. So if they haven't already by that stage, they should accept you as homeless by that point. And then the next thing the Code of Guidance says is that it should not be considered reasonable to continue to occupy accommodation once the court issues that bailiff warrant. So essentially, that's the end of stage 3. So the end of stage 1, it's unlikely to be reasonable to continue to occupy. The end of stage 2 is it's highly unlikely to be reasonable to continue to occupy. The end of that third stage is council should not consider it reasonable to continue to occupy once the court has granted that bailiff's warrant. So that fourth stage should never come into it, basically. You should never be in a situation where the bailiff actually has to kind of physically remove you from your home. So as we can see from that, it's pretty clear cut. But the local government ombudsman comes to the rescue, because they often flesh out these bits of ambiguity, and they just provide some very pragmatic examples. Now, there's 2 examples I'm going to draw from here. One is Brentwood, which was a case where the landlord actually took the council to court and got compensation, and the other one is Islington, where the tenant got £7,500 compensation because the council failed to pick up the fact that they were already homeless. They kind of told them to wait until the bailiff came. So in the Brentwood case, I'm not going to go through it in any detail. I put the link to it in the description because it's well worth reading. But essentially what happened was pretty simple. The landlord served a valid Section 21 notice. The council told the tenant to stay put, which then incurred costs on the landlord. And essentially the landlord just went after the council for those costs. And they got those costs back, as well as a small payment for the inconvenience of having to make the complaint, basically. So that was a pretty straightforward one, but it's interesting that even a landlord can get compensation because of the financial loss they've suffered because of this unlawful advice. And the Islington case is interesting. I mean, essentially it lasted over many months. I think it might have even been over a year that they dragged on for. But in that case, as I say, the tenant got £7,500, which was composed of different factors that kind of led to that amount being given, because it's a very large amount for an LGO to recommend that much. But interestingly, in that LGO decision, it also told the council to amend its policy, which essentially was tell people to wait until the bailiff came knocking. So they actually had a policy which was instructing staff to do that. and the LGO told the council to sort that out. So we can see why housing officers do this, is that often they'll be operating under the council's own policy, and often housing officers have never actually read the law or kind of read the code of guidance or anything, so they just basically do what they're told. They don't think to question it, they don't think they have any agency to challenge the hierarchy, and they end up doing unlawful things and breaking the law in a way that actually leads to considerable harm for a lot of people, and they don't think there's any other option. So as I say, if you're in this situation, kind of, I guess just to kind of bring it all back, you're in that situation, a valid Section 21 notice has been served, you're under the prevention duty, the valid Section 21 expires, and the council tell you to stay put and that you're not homeless and they haven't accepted the relief duty, then immediately you need to complain, and even that on its own is probably going to lead you to get compensation. So it should be obvious to the council that if the notice is valid, there's no defence, and the landlord generally does intend to seek possession, then it's unlikely to be reasonable to continue to occupy. Unless the council can give a good reason why they've told you to do that, or kind of what other realistic prospect there might be, they're going to get caught with their pants down basically when the LGO come knocking. So what you need to do is send a formal complaint to the Chief Executive Officer of the council, kind of title it formal complaint, put in these bits of the code of guidance. If the council officer has given you that advice in writing, then quote them on it. If they only said it verbally, then again quote them on it, but just kind of make the point it was said over the phone or whatever. This is why you should stay off phones, by the way, because it just doesn't, because they'll often say things on the phone they would never dream of writing down. But in that complaint, you'll need to educate the chief exec, and you're going to copy in the local MP, you're going to copy in the local councillors who are relevant. Again, I talked about that in the homeless application video I did recently. And you just want to lay out what the facts are. So you're quoting these bits of the code of guidance, you're saying what happened, and you're basically saying, first of all, I need to be treated as if I'm homeless now, because I am, because it's no longer reasonable to continue to occupy my home. And you can also, in that first stage complaint, start talking about compensation. And there's actually a local government ombudsman document called Guidance for Remedies. And essentially it lays out what kind of components you're going to add in. So you're almost certainly going to be owed some kind of small payment for the time and trouble to make a complaint, maybe a couple of £100, and then maybe another couple of £100 because of the distress that it's caused, because you've been left with this uncertainty. And then if you actually become liable for court costs, you can also claim that and kind of add that into the equation. So as I say, it's worth doing, and it's the only way in my experience at the moment in kind of 2024 of actually getting a council to follow the law, because what otherwise would happen is if you go back to the housing officer themselves and say, look, I've read the code of guidance, this is what it says, often they'll just dig their heels and they won't see sense. They'll kind of get themselves into a kind of state of mind where they won't be corrected by you. They'll just kind of double down and kind of end up in a bit of a mess, which is why you've got to go to the chief exec to actually get things sorted out. So as I say, I hope that helps. I'm hoping I've made it as clear as I can. Keep the questions coming. If you do want to find out more about this sort of stuff, we do online training every month or so, open to members of the public, very reasonably priced. Check out the Eventbrite link in the description, and also any sensible question in the comments I will take to the weekly live stream we do every Thursday, or most Thursdays, at 7:30 p.m. The reason we're having to do it is there's just not enough advocates out there who are actually going to do it themselves. So unless you can challenge councils yourself, you're probably going to get treated unlawfully and suffer the consequences. So